much harder to catch them, hold them accountable for that action. Does that answer your question, Your Honor?
It seems that there are, counter statistics to that illegal immigrants are actually less likely, I mean, it's a broadly broadcast statistic, less likely to commit crimes than actual resident citizens. So
I'm not sure where the statistics arrived from, Your Honor, but this was a case in 2011 which specifically stated that they are more likely indefinitely.
well, they may be a lot more likely to do illegal stuff because they're trying to evade detection, but the actual commitment of crimes by illegals is in our brief here is stated that they're less likely than indigenous American citizens.
Well, that may be a simple fact. If you look at the case of United States v. Portillo Munez, the reason they're here illegally and the problem with eluding detection is sometimes in order to do that, they have to commit to illegal activities. Now, specifically what those illegal activities are varies, but they are more likely to do that in order to elude detection. This makes sense under the case and under a logical premise of understanding that they're here illegally in the first place.
But if they're trying to elude detection, would they actually want to do?
Right, and that's a great question. The only problem is illegal things doesn't mean just violent crimes. Like applying for a job, for example. They're more likely to go and apply for a job without submitting proper social security numbers. They're more likely to not apply for taxes and not pay federal taxes, which is another crime. There's multiple crimes which don't have to be violent, but which breaks the law and poses an issue. Besides the fact that because they can't apply for certain jobs, and a lot of companies won't hire them and will in fact report them, they're more likely to get jobs that will end up harming other people. Does that answer both of your questions, Your Honors?
That's speculative.
Well, he did obtain a social security number and filed tax returns using an individual taxpayer identification number.
Yes, Your Honor.
So he still filed taxes and he got a social security number.
Right,
So
I'm not
how
talking
was that?
specifically in the case of Dominic Garcia, Your Honor. Absolutely, he is paying taxes, but if we looked at court precedent, not all illegal immigrants are paying taxes, and this would apply to them as well.
Okay.
Does that answer your question as well, Your Honor?
It seems that there's an overly broad definition of illegal aliens being applied here.
Your Honor?
The issue that the act was trying to address was this flow across the border, and not people who are responsible citizens and acting in every way possible as an American citizen.
Yes, Your Honor. Your Honor, the problem with the Act, Your Honor, is that the reason that, in fact, the Act itself states that there's a 5-year probation period. The reason for that probation period is to determine if they're actually responsible individuals. This is why the Act actually prohibits owning a concealed carry license until the 5 years are up, to make sure that they are responsible upholding the law citizens. Does that make sense, Your Honor?
Yeah, in this case, he seems to have already proven that.
Yes, Your Honor, but under the Act, there's a 5-year probation period, and absolutely Dominic Garcia may have proven that. Again, we don't know because they're more likely to elude detection, but even if we could prove that, that doesn't change the fact that it would set a court precedent for others who apply for the Act as well. Great. Moving forward, the problem is that we can't actually prove responsibility. We restrict the ability for minors to own guns. Why? Because we know that they haven't proven their responsibility to be able to own, possess, and use such a weapon. This is an issue. As an illegal alien, he hasn't actually shown this. Now, it may be true that in the specific case of Dominic Garcia, he could be responsible. After all, he is paying taxes, he is raising his children here, he has attended a public college. But this court cannot set a precedent as the Supreme Court for illegal immigrants applying for a concealed carry license. Remember, under the case of Hutron-Gizar versus the United States, it specifically stated that anyone crossing the border yesterday would be granted the same rights as the people crossing involuntarily. That means that anyone who applied for this act who has been here for a day would receive the same concealed carry license. This is why the Act addressed this with a 5-year probation period, to make sure that we were actually tracking each and every single individual to make sure they were responsible in the best way possible before granting them a right that could harm others and harm the public safety. Moving forward, this honorable court should never set a precedent that harms the public safety. In fact, it may be brought up that we don't have statistics. The issue with this is simple. The burden of proof relies on the petitioners. You see, Your Honor, we already have this as a court precedent. It's already been set in the Make America Safe Again Act. The petitioners are the ones trying to reverse the previous court's precedent. In order to do that, the respondents don't have to bring up statistics of why we should keep it. The petitioners have to bring up statistics of why we should reverse it. The precedent already exists that we have, under the Make America Safe Again Act, restricted this ability. And this honorable court should never set a precedent that harms the public safety or disables crime control. By allowing Dominic Garcia to apply for a concealed carry license, any illegal immigrant, even those crossing the border today, as long as they apply for the Make America Safe Again Act, could also procure a concealed carry license. This would greatly harm the public safety and inevitably make crime control increasingly difficult. This court cannot reverse the previous court's decision. Thank you, Your Honors.
Mr. Chief Justice, Associate Justice, may it please the court. My name is Matthew McCarthy, and I'll be addressing the Fifth Amendment issue in today's case, particularly in regards to Maria Alvarez and due process. Before I begin to analyze this case, I would like to inform the court that I'm losing my voice. So if you can't understand me, or if you need me to repeat something, I would be glad to do that for you at any time upon your request. I'll be answering two specific questions within this case. First of all, whether or not the Fifth Amendment applies to illegal aliens. And secondly, if so, to what extent does the Fifth Amendment apply to a hearing for a temporary release prior to the hearing for a final release? Now, I would like to clarify that we're not saying Mrs. Alvarez does not have the right to due process, but rather that actually due process has already been upheld. In the case of Knopf versus Shaughnessy, this honorable court ruled 6-3 that aliens cannot seek admittance under any circumstance because exclusion is due process. When Mrs. Alvarez illegally crossed the border, she received a de facto sentencing of due process, that being deportation. Thus, due process was upheld when she received that deportation sentencing. So that answers the first question, that yes, she does have the right to the Fifth Amendment, and that due process has already been upheld. Now the question is, to what extent does the Fifth Amendment apply to illegal aliens requesting a hearing for a temporary release prior to the hearing for a final release? And we can look at a few court cases to answer this question for us. The first one we can look at is Greenholz versus Inmates of Nebraska Penal Complex in 1979. And actually the opposing counsel brought up this case saying that detainees had the right to be released under the appropriate circumstances. However, this is slightly misleading because they did not say what those appropriate circumstances were. In this case, the court ruled that there is no constitutional right available to those who are released before the expiration of a valid sentence. Now, in Mrs. Alvarez's case, as we've clearly determined, the valid sentence is deportation. No tricks, no loopholes, no jumps, no anything of that sort. It's just that simple, deportation. Because she has not served that valid sentence, she does not have a constitutional right in this scenario. Now, in the case of Jennings versus Rodriguez in 2018, just last year, this court set a new precedence contrary to the one of Hamdi versus Rumsfeld in 2001, saying that detainees do not have the right to periodic bond hearings during their detention. Now, remember, Mrs. Alvarez has requested 2 hearings. The first one is her final hearing to determine her guilt or innocence, which she has every right to. But the one we are asking, that the petitioners are asking for today, is the hearing to be temporarily released, as she is promising to return for her final hearing. And this is a privilege. This hearing is not something granted to her under the Fifth Amendment or due process, and there is no case that this court has seen that says that she has that right to that temporary hearing, but rather that is a privilege that is given to her and not something guaranteed to her under the Constitution. Now, once again, in the case of Jennings versus Rodriguez, and also in the case of Hamdi versus Rumsfeld, this honorable court ruled that you can only be released early if it's for an urgent humanitarian reason or if it's for a significant public benefit. Then the facts of these cases do not show either. There's no urgent humanitarian reason that Mrs. Alvarez is experiencing, and obviously she would not be providing a significant public benefit, but actually harming the public. Now, the petitioners in this case argued that her personal interest was that she needs to take care of her grandmother. However, we are providing no details under this as to the situation of her grandmother. But moreover, and more importantly, if you
So,
did...
excuse me, but it seems like you were talking about public benefit here. she does have a humorism, but the public benefit is that it costs an extraordinary amount of money to keep somebody detained. We kept her for over a year here, you know, and thinking to what point, if you release this person and she's low risk, you know, you've now created room for people who are potentially, you know, really harmful or identified as risky in your detention centers, and you've lowered your costs.
Well, Your Honor, to respond to that, as far as room goes, the detaining facilities have plenty of room to house anyone, and currently we have not seen a problem as to being short on room. Now, for the reason we are detaining her is for the sake of public safety, and this is farther down the list. Would you like me to jump to that now or move on to it later?
I'd like to demonstrate where she was a threat to public safety.
So the reason is because she is deemed as not threatening. Now that sounds backwards, but remember what's on the opposite end of that is threatening people. It is in the interest of the government that we hear those cases and deal with the people that are threatening first before moving on to those that are non-threatening. And to put it in simpler words, we need to deal with the dangerous people first, as they are posing a greater threat onto our society before moving on to non-threatening people such as Ms. Alvarez.
So that creates the rationale for keeping people in prison in perpetuity, because we don't have the capacity to expedite their deportation.
Your Honor, that's not what I'm saying. The courts absolutely have the ability to hear all cases within a timely fashion. However, we are just simply prioritizing these cases as they come in to hear threatening citizens first before non-threatening citizens. We're not saying that we're ignoring Mrs. Alvarez or that we're going to detain her.
No, but de facto, we don't have the capacity to deal with her in a timely fashion. Hence, you know, we've got her on this, endless, imprisonment.
You're right, Your Honor, and that is not actually because we are dealing with necessarily threatening before non-threatening, although that does have.
Yes, we just said that.
But the other part is that there is an extreme backlog, and that is why
It's a capacity issue, and you're really talking around this.
Well, no, as far as capacity issue, what I was saying was that the detaining centers have plenty of room, and that we're not worrying about not having room to be detaining people. As far as backlogs, from what I understood, there are over 60,000 people being held every day by the ICE facilities. That is why it is taking so long, is because there's so many cases that the courts need to deal with. Does that make sense, Your Honor?
Yeah.
Thank you. Now, the government has multiple compelling reasons as to why be detaining Ms. Alvarez. And the first one, as I had answered your question already, is that we need to deal with the threatening cases first. But the other is that actually Mrs. Alvarez is taking an American job, sending the money back to her grandmother in Mexico, and then not paying taxes on it, which obviously harms the public and the citizens of the United States. Her personal reasons to be released went nothing beyond her grandmother and that she needed to take care of her. And if you ruled in favor of the petitioners, this would set a precedence that anyone, perhaps with a grandmother, an extended family member, someone could just claim that they needed to help that person and thus be released.
Mr. McCarthy, would you agree that there are many jobs in the United States that normal Americans won't do, such as meat processing, house cleaning, yard maintenance, etc.?
That is definitely possible, Your Honor.
I would think your argument that she's taking an American's job at this point would be specious.
She's taking a farming job, which is a higher paying job. Therefore, we are assuming that it would be within the interest of the American citizens to get that job. And even if not,
I would love to see you provide any evidence that an American will take a farm worker's job. I mean, an American citizen,
Your Honor, I'm not necessarily saying that someone will or will not take that job. Rather, we cannot be setting a precedent such that illegal immigrants can just be coming in and taking our jobs like such. Granted, yes, there are jobs that American citizens might not take, but it definitely is reasonable to say that there are jobs that Americans would take that an illegal immigrant could be taking. Does that make sense, Your Honor? Thank you. Now, the question now is that why is she not getting hearing? The government clearly has a good enough interest to detain her, and Mrs. Alvarez does not have a valid enough interest. And once again, this comes back to what I already said previously when answering a question, is that we need to hear the threatening people's cases first before moving on to hers. So in this case, we can see two main things. That first one, yes, she does have the right to due process, but actually that due process is already upheld when she was issued a deportation, and that the government has substantial interest for the sake of public safety to be detaining her. My co-counsel and I politely request that this honorable court uphold the previous court's decision. The issue in today's case isn't whether or not Mrs. Alvarez has the right to due process, because due process was upheld when she was issued a deportation. But she threw that option out the window. Because she knowingly accepted indefinite detention, the Fifth Amendment no longer protects her.
Your Honors, Mr. Garcia and Ms. Alvarez share one thing in common. They both deserve the protections of the constitutional rights upon which this nation was founded. We first turn to the Second Amendment and Mr. Garcia's claim that the Second Amendment has been restricted in an unjustifiable manner. We notice that Mr. Wilson's entire case precedence was first of all only circuit court cases, but furthermore referenced only illegal immigrants. And as noted before, this court has held that the only way that someone would be labeled an illegal immigrant is if they were able to be excluded or deported. And because applicants for the Make America Safe Again Act may not be deported, this definitionally means that according to this court's standard, Mr. Garcia ought not to be considered an illegal alien. None of the case law that Mr. Wilson cited ought to apply here. We now turn to the government's interest in restricting that right. And Mr. Wilson's contention was that the burden of proof is upon the petitioner to prove some kind of statistics that there is no justifiable restriction. I would turn that burden back upon respondents based on this court's precedent in DC versus Heller. And in that case, this court remanded a ban on firearms, a ban on assault weapons more specifically, back to the lower court based on the same thing that respondent has in this case, a lack of statistics. Because respondent lacked statistics to prove that assault weapons posed a great firearm risk, the court remanded the case to a lower court. And until respondent can prove that issue, according to this court's precedents, the burden of proof is upon the respondent to prove that there is a justifiable reason to impinge on the constitutional rights of Mr. Garcia. We now turn to the Fifth Amendment issue and Mr. McCarthy's claim that Ms. Alvarez does not deserve the protections of the Constitution because she has already been afforded due process. I direct this court back to its ruling in Wong Wing versus United States, where it held that deportation is not to be considered a punishment. If deportation is not a punishment, and Ms. Alvarez has not been deported yet, by definition, she is pre-sentencing. She is pre-punishment, and therefore she is not post-punishment, as respondent would claim. Mr. McCarthy's entire argumentation is predicated upon the fact that Ms. Alvarez is considered post-sentencing. But because this court has held that there is no sentencing with regard to a non-punishment entity such as deportation, she is not clearly post-sentencing. Even if this court were to hold that she is post-sentencing, it still ought to uphold her due process rights. And according to any court that has addressed an issue of due process, they have always considered the fact that there has to be an opportunity for release. In this instance, we are not asking the court to grant her release, but rather to grant her the opportunity to have a hearing for her release. That is her due process right, and that is what this court ought to uphold. We turn to the Matthews versus Eldridge test.
So I may intrude real quick. So due process is whatever is authorized by Congress, isn't that correct?
No, Your Honor. Due process has been afforded by the Fifth Amendment of the Constitution and has been articulated by this court. And this court has held that due process entails the opportunity for release. The reason for this is because until there has been a fair trial, you cannot legally detain an immigrant without affording them an opportunity for release. And because deportation never ensures a fair trial and never presents a legal trial with true evidence, there is no right of the government to detain Ms. Alvarez indefinitely. Because Ms. Alvarez does not pose a threat to public safety, under the Matthews versus Eldridge test, the government's interest is null. The government has no interest in detaining her because she's been deemed as non-threatening and not a flight risk. If we compare Ms. Alvarez's liberty interest to the government's interest of preventing her flight, we find that Ms. Alvarez, the case weighs in Ms. Alvarez's favor.
If you could define something for me, could you define the people and actually have two more after that?
I see my time has expired. Would you allow me to answer your question, Your Honor?
Goes ahead.
Your Honor, your question is regard to the Fifth Amendment. Is that what you're answering?
Second and the fifth.
Wait, wait.
As a general aspect, since we are talking about people who are being deemed as illegal immigrants, okay? Define the people real quick, and then I want you to put the word political and the word community real quick.
Your Honor, when we're deciding whether we should afford these people the constitutional protections of the phrase "the people," we ought to rely on this court's precedents. And in Verdugo or Urquidez, this court held that aliens receive constitutional protections when they are within the territory of the United States. They are within the meaning of the people by this court's own precedents. And based on any case that this court has ruled on, from Bridges versus Wixon to Russian Volunteer Fleet versus the United States, Wong Wing versus the United States, Plyler versus Doe, Yikwo versus Hopkins, aliens always receive constitutional rights. And to your question of the definition of political and community, again, Your Honor, respectfully, that is not the question that this court is asked to address today. Rather, that it is the claim of the petitioner that it would be a deviation from this court's precedents to rule in favor of the respondent and rule that an alien does not have any constitutional rights when every single other court case that this court has held has protected aliens and their constitutional rights. To uphold the principles of constitutionality, I urge this court to reverse.
Now I am going to ask you, or tell you one question I want your thought, or tell you something and I want your thoughts real quick. So, political community only regards to the government being accountable of the people and the people under a government. If they are not under the government by citizenship, how can they be a part of the political community?
Your Honor, our contention is not that the illegal immigrants are part of the political community, but rather that they are protected by this court's precedents. And it is not the issue of whether they are within the political community, but rather if this court has held that aliens ought to receive constitutional protections. And under any court case that this court has held, the aliens do receive constitutional protections.